We'll be presenting on our handbook, which focuses on employment law of migrant work, specifically the Temporary Foreign Worker Program. So we're currently law students, so we wanted to reiterate that this isn't legal advice, it's just for information purposes only. At the end, we will have time for questions, and we have a feedback form as well. So if someone wasn't able to attend, we can send that out to them. With that, I'll turn it over to Alana for a brief overview of our handbook.
Yeah, so this is just the overview. We're just kind of outlining what we're going to go through. So we're going to go through some definitions that you're going to hear throughout our presentation. We're going to go through contracts, which is the bilateral agreements. We're going to go through law that covers 3 pieces of legislation, reprisals, and how to file a claim. And then we'll go through advocacy, being both legal and non-legal, and then feedback. And we just also want to note as well, this is not everything within our handbook, it's just certain things.
So for the purposes of our handbook, we only focused on the 3 of the temporary foreign worker program streams. So the seasonal agricultural worker program, agricultural, and the low wage streams. The law appears to not be judgmental on the surface, but the way it is applied creates real life consequences for individuals. The way in which these programs were created was to fill in a labor gap in Canada, but to not allow for migration of racialized individuals to Canada. This can still be seen today by how migrant workers are subject to certain exemptions, which allow employers to take advantage of them. Our handbook addresses what rights are afforded to migrant workers, but also what actually happens in reality for workers in Canada, which has been heavily highlighted throughout the summer during the pandemic.
So next, we're just going to go through some definitions that we've had modified from an employment law textbook. So the first definition, a bilateral trade agreement. So this is a trade agreement between 2 nations. An employment contract defines the conditions under which the employee will provide labor to the employer in exchange for a monetary benefit. Reprisals, when an employer or manager penalizes or threatens to penalize an employee.
So a work permit is a legal authorization issued by the Canadian government that permits a non-Canadian citizen to temporarily work in Canada. A wage recovery mechanism is a legal provision allowing workers to claim unpaid wages before a justice of the peace or magistrate. Equal pay for equal work is a statutory model that requires equal pay for men and women who perform substantially similar work in the same establishment. Breach of contract occurs when a party to a contract violates one or more terms of a legally binding contract.
So next we have termination pay. The payment owing to a dismissed employee under employment standards legislation that is in replacement of working statutory notice. Severance pay, compensation that an employer must pay to a qualifying employee who has been dismissed. And class action, a lawsuit in which a group of people join together as they have suffered the identical or similar legal wrong at the hands of the same individual. A class action must be approved by a court before it can proceed.
So next we'll provide a brief overview of the contracts and law in Canada, which outline a worker's employment terms and rights. So although there are the contracts and employment legislation, migrant workers often do not have equal protection to these laws, or in the case of the contracts, it hinders their ability to actively advocate for themselves. So these bilateral agreements outline the scope and period of employment, lodging, meals, and rest periods, deductions of wages, travel, obligations of employers and workers, and transfer of workers. The benefit of the bilateral agreements between Canada and the workers' home countries, mainly Mexico and the Caribbean countries, is that they provide Canada with cheap and expendable labor. They offer temporary work permits. Workers are unable to seek a clear and easy pathway to citizenship through the program. As such, Canada can utilize the workers for their labor, but not have to commit to providing them with any concrete benefits. We also want to discuss some of the problematic sections of these contracts. For both the Mexican and Caribbean contracts, the hours worked is 40 hours a week. However, there should be greater protections for workers to ensure that they are not being overworked. There should also be better ways to ensure that a worker is being given their 1 day of rest, especially if workers feel pressure to work more if they are being compared or fearful of facing reprisals, especially seen during the pandemic. The contracts deal with trial periods. We believe that this should also be extended to provide the worker an equitable opportunity to maintain their employment. And regarding early ending of an employment, workers should have an opportunity to go before a hearing and be provided detailed reasons as to why they are being released. This will enable the employer to be held accountable for their actions if they are based their decision on punishing the worker. So our presentation provides an overview of two relevant pieces of legislation, the Employment Standards Act, called the ESA, and the Employment Protection for Foreign and Nationals Act, the EPFNA. The ESA is an Ontario piece of legislation that outlines minimum standards for workplaces. Agricultural employees are protected under the ESA. The relevant standards and rules depend on the category the worker applies under. The EPFNA applies to workers that are working in Ontario or are planning to be in an immigration or foreign temporary employee program. The Occupational Health and Safety Act sets out roles, rights, and responsibilities for employers, supervisors, and workers.
So for legislation, I'm going to start off with the Employment Standards Act. And there's three significant categories that apply to agriculture employees. And this essentially determines the type of rights you have under the Act. So these three categories are farm employee, harvester, and then near farmers. So all three types of categories have these rights under the Act. Regular payment of wages and wage statements. This means that the employer has to have a recurring pay period. Leaves of absence, which provides qualified employees with the right to take job protected leaves. Termination and/or pay and severance pay. Equal pay for equal work. Harvesters and near farmers are given additional rights under the ESA. This includes minimum wage and vacation pay, and harvesters are also given public holidays. However, even with this, they are subject to exceptions and qualifications. So migrant workers are some of the most vulnerable members of our society and have few mechanisms through which to be heard. This is even more evident through an exemption under the ESA known as one work deemed to be reformed, exemptions and special rules. So an example is minimum wage. So under this exemption under Section 2, subsection 2, farm employees are exempt from minimum wage. The implication of this is that there's no concrete way to ensure that workers are being paid fairly. Now referring to the EPFNA, there's just a few sections that we wanted to highlight. So the EPFNA prevents recruiters from charging fees for any service, good, or benefit provided to the foreign national. Another important aspect of it is that it prohibits employers from taking property. So this is especially important for things such as passports. Furthermore, it prohibits a recruiter, an employer, or a person acting on their behalf from intimidating or penalizing a foreign national for essentially asserting their rights underneath this act. So the next section we want to focus on is reprisals. If a worker is acting on their rights, they should not be punished. However, we also want to recognize the limitations of bringing forward claims. Unlike those with citizenship or permanent residency, migrant workers can be concerned about losing their immigration status or having to leave Canada if they try to enforce their rights. It may be particularly difficult to bring these claims to the courts or tribunals because they may be able to award a payment, but not a work permit. So just starting with the Employment Standards Act, Section 74, subsection 1 of the ESA prohibits reprisals. So I just kind of want to note a few things. Employers cannot penalize or threaten to do so if an employee asks the employer to comply with the act, asks questions, or files a complaint, if they give information to an employment standards officer, and if they are participating in a proceeding under the act.
So if it is a health and safety matter, Section 50 of the OHSA protects workers from reprisals. So the worker is protected from reprisals if they have acted on any of their rights under the OHSA, such as refusing to perform work they believe is unsafe, followed or asked their employer to follow Ontario's occupational health and safety laws, given information to a Ministry of Labor, Training and Skills Development inspector, or testified at a hearing about occupational health and safety enforcement.
So our next section is just going to be on advocacy, both legal and non-legal.
Okay, so to begin with the legal means that we've explored, a class action may be a legal avenue for migrant workers to use to bring a claim against an employer in court. A class action is a unique kind of lawsuit where a group of people who have the same problem get together and sue at the same time. The group is called the class, and the size of the class can vary. A class must include at least 2 people, but there is no limit to how many people can be in the class. Ultimately, the migrant workers must have faced the same legal issue against their employer and meet the other requirements of certification in order to proceed. So we wanted to note some concerns and hurdles for class actions. Firstly would be to find a law firm or a group of lawyers to take on the case. Reprisals if the employer hears about this. Also the timeliness of a class action, it can be lengthy, between 2 years or longer. Having access to information, and then lastly, having an individual to become the representative plaintiff, which would mean having their name on the record. So we wanted to know one successful example from British Columbia in 2013 with Dominguez and Northern Properties Corporation, where workers under the temporary foreign worker program were employed at a Denny's restaurant, which they filed a class action lawsuit for their employer failing to pay overtime and committing to various breaches of the employment contract. They were certified in court, and it was interesting to note because whoever joined the lawsuit, there was an order that there would be no repercussions faced from the employer. And ultimately the settlement was valued at over 1 million.
So the next legal action we would want to, or like legal advocacy we'd want to talk about is a demand letter. So essentially a demand letter, can be important because it could prohibit the employer from continuing their actions without having to first proceed with legal action. However, it should be noted that this should also be exercised with caution. The main reason being is you don't want the employer to have like further reprisals against an employee. So we also note here some non-legal means, such as using social media. So J4MW, utilizes Facebook, Twitter, and Instagram, which brings awareness to the community and enables different partners to come together. There's also organizing and strikes. Furthermore, we have here consultations, which actually currently happened with the Government of Canada seeking to discuss living conditions of workers.
So on the screen, we wanted to post our public legal education material that we've been working on. Mm-hmm. So far we have a document on reprisals, another one on how to bring a claim to the WSIB, which is the Workplace Safety Insurance Board, and then how to file a claim in regards to Employment Standards Act and the Employment Protection for Foreign Nationals Act. We'll also be focusing on other aspects. As Alana mentioned, we didn't include it in our presentation, but such as wage theft and the issue of under or over hours worked. So we have 2 videos, if we have time to present them. They're just a sample right now. So one is on reprisals and the other is on how to file a claim. Hopefully they can be translated, but they're just little cartoons on simplifying the procedure. You can see it. Can you hear it or? Okay. And here's the second one. We're still working on the glitches and for the videos. It would be difficult to begin one without the workers physically here, as we've learned throughout our research. Um, well, firstly, we would need a worker or more than one to be willing to be legally documented on the record for as a representative plaintiff. So to begin with, it would be difficult. However, it is possible, as we noted in that BC case. Um, there were workers joining the class action even while they were still employed at that specific farm, and there was an order by the court saying that the employer would not be able to enforce any repercussions for workers who wanted to join and continue to be a part of the class action.
Like, it's definitely something more that we would have to look into to kind of see like all the different possibilities and the way in which it could be brought forward.
Yeah, and I know that's currently one of the concerns for the consultations going on with the government. The workers aren't physically here, and it's difficult to have their voices heard.